Right now, while you're watching this, there's a real chance your neighbor already legally owns a section of your property, and not a single piece of paperwork was signed to make it happen. It's called adverse possession, and depending on which state you live in, the clock to take your land can run out in as little as 5 years. By the end of this video, you'll know what to do if you think you're already too late, the one document that can wipe out their claim almost overnight, and the actual court process that decides who owns the dirt under that fence. Before I get into it, this is legal education and not legal advice, so check your local rules before you take action on any of this. The first thing most people get wrong is they assume adverse possession is some weird loophole that only matters for abandoned cabins in the woods. The reality is that the most common version occurs between regular neighbors over things that look completely boring from the outside, like a fence that drifted 6 inches across the years, a garden bed that crept past an unmarked line, or a driveway that was poured a foot wider than the deed actually allows. That boring stuff is exactly what courts end up handing over. So how does someone actually take your land through this law? They have to prove 5 separate things at the same time, and if even one of those falls apart, the whole claim collapses. The first is that their use was actual, meaning they physically used the land the way an owner would. The second is that it was open and notorious, which is just legal speak for visible enough that a reasonable owner should have noticed. The third is that it was exclusive, meaning they used it on their own and didn't share it with you or the public. The fourth is that it was hostile, which sounds dramatic, but it really only means that they used the land without your permission. And the fifth is that all of this happened continuously for the statutory period in your state. That statutory period is the part that catches almost everybody off guard. In California, it's only 5 years, with the added requirement that the claimant was also paying property taxes on the disputed property. In New York, it's 10 years. In Massachusetts, it's 20 years. Colorado runs 18 years, or 7 if the person has a defective deed and was paying taxes the whole time. Texas runs anywhere from 3 to 25 years, depending on how the facts line up. The deadline is shorter than most people think, and it's already ticking somewhere on someone's property as we speak. Once it expires, ownership ripens in the eyes of the law, and you don't get to start over. You can still fight back, but now you're fighting from behind, and the longer you wait, the steeper the climb gets. Let's say you suspect the clock is already running on your property. Maybe you just bought the place, or maybe you finally got a real survey done and discovered your neighbor's fence has been 3 feet over the line since back when George W. Bush was still in office. What can you actually do about it? Your first move is to attack the 5 elements directly, because each one is a separate point to defeat the claim. Was their use actually continuous, or did they leave the property empty for a year while they worked overseas? Was the use really visible from your side, or hidden behind hedges where no reasonable owner would have spotted it? Each one becomes a defense. The plaintiff carries the entire burden of proof, and in most jurisdictions, they have to prove every element by clear and convincing evidence, which is a much higher standard than the regular civil one. You don't have to prove they're wrong, they have to prove they're right on every element. Your second move is the one almost nobody knows about, and it sounds completely backwards when you first hear it. You hand the neighbor written permission to use the land. The reason this works comes back to that 4th element, hostility. Adverse possession only counts when the use is happening without your permission. So the moment you give written permission, the hostility element disappears. The clock doesn't just pause, it resets all the way to 0. The document is called a revocable license, and it's quietly the most powerful tool a homeowner has in this entire area of law. The letter itself is short. It identifies the exact piece of land in question. It states that you, as the owner, are giving the neighbor permission to keep using it. And it makes clear that you can revoke the permission anytime and for any reason without notice. Both of you sign, and you keep a notarized copy filed alongside your deed. Picture how this actually plays out. Your neighbor's shed has been sitting on your land for 9 years, and in your state, the threshold is 10. You're one summer away from losing that piece of property forever. You walk over with a one-page letter saying you're giving them permission for the shed to stay where it is and that the permission can be pulled back at any time. They sign it, and 9 years of accumulated possession effectively disappears. If they refuse to sign, that refusal becomes evidence in your favor. Either way, you walk away ahead. California even lets you go a step further by posting signs that read, "Right to pass by permission, revocable at any time," under Civil Code 1008. And a few of those signs at $30 each can stop a prescriptive easement claim from ever forming on a path or driveway. Now, what happens if the damage is already done? They've been there long past the deadline. They refuse to sign your license, and they're walking around acting like the property belongs to them. At that point, you file what's called a quiet title action, which is a lawsuit you bring in the county where the property sits, asking a judge to officially declare who owns what. The court looks at the deed, the survey, tax records, witness testimony, photographs, and even old aerial imagery from sources like Google Earth. So basically anything that tells the real story of who possessed what and when. At the end, you get a court order that wipes out competing claims and locks in legal ownership for whichever side wins. The thing most people don't realize is that even if your neighbor has technically satisfied all 5 elements, their ownership isn't real to the outside world until a court actually declares it. They can't sell that property, they can't get title insurance on it, and they can't borrow against it. The land sits in legal limbo until a quiet title judgment comes through, which means either they file suit to confirm what they took, or you file suit first to wipe their claim out before they can. And every year you wait, more evidence stacks up in their favor. If anything on your property feels off right now, whether it's a fence, a shed, or even a driveway, get a survey scheduled this week and draft a permission letter to go with it, because those 2 moves can protect your property and set back the clock.